fast chama Wontumi. The case in this woman, no judge in this woman file addresses on or before 17th of this month. Now, 3rd July. One more, one for Akemu Emra. Now, multimedia, someone 10 times say, and if you are to be 8 years, 10 years, no man has such a home. Judging candid opinion. Let me be very blunt and honest and sincere. Maybe I'm not comfortable the rate of it. Case in A2 Mikasa. This is my personal view. I may be right, I may be wrong. Because cases of this nature, and my cases be bring war. When I said that man in 2 Milika. And yes, I said that what do I say? Obin Abrabo, Obin Yasio. If you come in Casa, you call some boat Milika. You look at the cases very well. Especially if you are for the accused person. You look at the cases very well. From so, prosecution per se in 2 Milika. And then you know how the man 2 Milika. That is why I say, who has started. I said, incident where some money 2 Milika for some period. Incident, so no one home so. So sometimes when you are doing this thing, you need to be very careful. You should tread cautiously. The main cause, the name, or I case, why? But let me say in my candid opinion, my personal opinion. I will from the brother of Bribuan too technical. Bribuan too technical. And yet too technical. And yet, who say we human life? Now, who say we human life now? I just say you must go all out. Look, one bad focus here, you're calling. I find the motion. I might public domain, but I find a motion at the High Court. What is the purpose of that motion? My filing a motion or notice to prohibit the Secrét Court judge from hearing the matter. Why? Why? Because Secrét Court judge, you know, they are reminded I'm back for me. Okay, I say me man bail kwa, obakwa kwa ye boni view. Tell you. Say me man bail kwa, obakwa kwa ye boni view. Entinya to see this, no. Judge, you know, sabi, the way I mean, can you know, why an argument? And you know, in law, it means that he has descended into the arena of the conflict. I'm not attacking the judge. I am just raising the issues. So I filed a motion or notice to prohibit the Secrét Court judge. And I believe that by now, it will myself. And I think it's coming on the either 10th or 12th of the 12th or 13th June. I sought their permission. Because I said, me raising. If you buy a query, you know, me catch me pan say, some money, but for not on Pama could go upon common chambers one. Never to bank canning, never because then there, I said me do blue. Substantive case, the other day, I cocaine submission by Mudakron. And about Pama go for Danny for Bench. As I said, me do blue, and my woman, because they are all lawyers assistant. When I have went to my emotion, not a failure. I can't do it without even giving them the opportunity to read. Upon commission, adoption, voter junior, a fuck motion. Now I make but as I say, me do duo and my woman. Maybe I'll go no matter, that's the opportunity. That's a bank there. Because, so sometimes when lawyers we are doing cases, sabi kafrachu. Number one, saying panic. What was the Mahama a petition against Namado in 2021? You know, we were about 10 lawyers, 10 or 12 lawyers, MPP Kokomlemle, MPP head of about 12. We were about 12 lawyers. A lawyer for Pare, Dumianu, and I share Kokomlemle, MPP. Now, your final petition number 1, or can say petition number 2. Dumianu, and I do 9 cry. I'm not by Frank Davis. So who is that? I could jump out. I could general and Frank Davis, no, Sylvia. Yes, who the Sabami and Sunny Begin there. But yeah, defense for no mere union. A lawyer for Makuma could do you. So as lawyer sometimes, Mr. Nicole, cases in the bar. Mama young Catabia, Yamin Kwame Clank, and Timin Kwan, no. You can assemble about 10 lawyers. No money now, what the margin, no question, the amount. Could they wait a next American? Yeah, could be an petitioner, President Mahama, you know. Your difference, you are about 12 lawyers. So, well, let's wait and see July 4th. But my candid opinion, the American case in A2. Now me are scared, now me are worried. Now me are scared, now me are worried. This is my personal opinion. Wontumi is my friend. Wontumi is my younger brother. Wontumi is my boss. Wontumi is my regional chairman. Wontumi TV. Now I'm regional senator because every Saturday I benefit from Wontumi. Wontumi should benefit from me. But until I don't have the way to express my personal opinion. So let's wait and see. I am not like commentators. But I don't do that. I don't do that. And if you don't catch, oh, now say, because I got a cranky to phone. Into I'm by a mother or young baby. Now I'm going to my young baby before. I say, many on my bone for me. I don't know, baby, I'm coming my album of way. How is that? Yeah. If you are offended by me, not correct. So be it. If you are happy about me, not correct. So be it. Obianim Ghana has said, me cannot correct. Never minded. The Minyan Kopono, go with principles and morals and good conscience. Now make do what you believe. June 4th. And this is the first celebration. I am about the bomb my basket. The day you know about celebrating. No, that I said, let's resume this year free June 4th. I'm people for being rubbish. No, don't rubbish. Women see celebrate and can make MPP. Minority won your press conference and academic day. To tell the whole world that there are lessons to be learned from June 4th. Prepare anybody a woman. Na ninyi na no Jerry John Rollins nka o confess here. Some of the Kunku folk are not active participants of June 4th and 31st. And so, also national reconciliation. John Rollins, but you know,
his company are standing trial over allegations that mining activities were undertaken within their Summary Boy concession and without the requisite authorization. The prosecution alleges that these activities occurred within a forest reserve and constituted unlawful mining operations. The Supreme Court has also dismissed a suit filed by Imani Africa and security analyst Professor Kwesi Inin challenging the president's authority to appoint and remove heads of security agencies. Delivering the judgment, Justice Gabriel Puaman, who chaired the panel, said the court found no merit in the plaintiff's claims and accordingly dismissed all the relief sought. The court also ruled that the offices of the Inspector General of Police and the Director General of the Prison Service do not fall within the protective scope of Article 191 of the Constitution. It further held that the appointments of the Chief Fire Officer and the Comptroller General of the Ghana Immigration Service are governed by statutes and remain within the President's discretion as part of his constitutional responsibility for the nation's security.
In a sense, what we asked for, they haven't given us. But they've decided what to give us, and they've given that to us. And that's what they explain, that in their mind, the offices are not the same. In our law, as it is written, there's no distinction per se. All right, they all come under 191. They are public servants. They are protected, you know, and all those things that we wrote. But the IG, the Supreme Court is saying that two of them should be specially treated, and then the others should also be separately treated. And they gave reasons like the security of the state and the president is the head of the security and a couple of things, which it's not clear to us. We went to court on the basis of the law as it is. And the basis of the law as it is that all these offices are public offices. They are protected under Article 191. You can't just get up and sack a person because you assume office. Assuming office as a president or anything is not cause for sacking others, and there are many cases like that. So we will wait and read the full ruling of the
Chairman Wontumi. Among other things, Otredako Mensah admitted during cross-examination that he was unaware of the conversation between Wontumi and Henry Okumi, who is the prosecution witness number 2, which resulted in the latter mining on his concession at Samreboy. Lord Edwasari reports.
Bernard Enchi-Boisiakon, also known as Wontumi, is facing charges of assigning mining rights without the approval of the land minister and facilitating illegal mining operations on the Samreboy concession in the Western region. Former Western Regional Minister Kwabena Otredako Mensah, who also served as chairman of the Western Regional Security Council, told the court during his testimony that a formal complaint was received from Akonta Mining about the invasion of illegal mining operators on Wontumi's Samreboy concession. He affirmed that the complaint was written and documented and was urgently acted upon by the Security Council, as it was consistent with several complaints from other mining rights owners in the region about organized criminal groups invading concessions and carrying out illegal mining. During cross-examination by Deputy Attorney General Dr. Justice Fremsai, the former minister, who served from 2017 to 2025, disclosed that he did not personally know the prosecution's second witness, Henry Okum, the individual who testified that he was commissioned by Wontumi to mine on his concession. Henry Okum had further told the court that Wontumi did not produce any formal mining rights. Asked about the engagement between Okum and Wontumi, Dako Mensah indicated that he was unaware of the interaction between the small-scale miner and the NPP Ashanti Regional Chairman. Lead counsel and the Apia Kubi expressed satisfaction with the outcome of the testimony.
Was to indicate that it was rather Chairman Wontumi and his company that made reports to his office as then chairman of the Western Regional Security Council, and that all efforts made by the Security Council to ward off illegal miners and also to redeem or reclaim the lands so degraded by illegal mining were at his instance. So today's evidence sits very well with our own, and indeed it exonerates people who engage in reclamation of degraded lands.
And we are streaming on Facebook and on our website, so be a part of the show.
We begin from the United Kingdom, where President John Mahama has stated that the Human Sexual Rights and Family Values Bill passed by Parliament is not yet ready for presidential assent, noting that the process still has some way to go. Speaking at Chatham House in London on Monday, he explained that concerns have been raised regarding the bill's passage, particularly issues related to quorum and procedural compliance during parliamentary proceedings.
Parliament has been considering it, and it was supposed to have been passed last week. There have been a few issues raised. One, that there wasn't quorum when it was passed. That's an issue that has come up. And then two, there were some procedural lapses in terms of its passage. I just got some communication that the speaker was reading a statement to address the issue of the lapses in the passage of the bill. And so, like I said when I was the opposition leader, the president has a number of options in this matter. It must come for assent, and so once the president gets it, you go through it because you are not part of the discussion in Parliament. And so the legal representative, the legal counsel in the presidency and the Attorney General would sit on it because it was a private member's motion. Right. This was not a government bill. And so we'll look at it and make sure that everything is in order before the president is advised to assent. The president has another option if there are some things that he thinks are a problem. He can refer to the Council of State for advice. The Council of State is an advisory body to the president, and so they will take a look at it, and then they will advise the president. And if there are issues, substantial issues that are raised, the president would return the bill to Parliament, indicating exactly what the issues are. And so there's still quite a while to go before that bill becomes law.
Thank you.
In a related development, the Speaker of Parliament, Alban Bagbin, says he was surprised at the speed by which the Human Sexual Rights and Family Values Bill was passed by Parliament. He has, as a result, summoned the two leaders of the House to explain matters to him, insisting such a critical bill must be passed by consensus.
We know the copious instruments and laws on human rights. All over, we have to go through all, from the UN Charter to the African People's Rights and what, all, we have to go through all. And we have also our development partners who have a lot of contributions to make. We have the United Nations coming in with proposals on memo and everything. We as Ghanaians also have to dig deeper into our cultures, our customs, our values before we came out with what was passed on Friday. And in fact, when it was passed on Friday, it was even a surprise to me. Because I knew that we were going to start the consideration of the bill. And that was the instructions I left before I went to attend to other activities. It was Friday, and members wanted to go home early in their constituencies, what we were going to see today. So I knew they wouldn't have completed. But all of a sudden, I read about this passage. I reacted, and later I saw on TV all the things that happened. And so this evening, I've asked the leaders to meet me in my office. So they will be here for us to go through it. This is such a critical bill that we believe there must be consensus. But it's not about passing bill. It's about implementing it and making sure that it benefits.
Meanwhile, the minority caucus in Parliament has accused government and the ruling National Democratic Congress of weakening the Human Sexual Rights and Family Values Bill through extensive amendments before its passage by Parliament last Friday. The Member of Parliament for Asen South, Reverend John Ntim Fodjo, was addressing a media briefing.
According to Reverend John Ntim Fodjo, the changes proposed in the Human Sexual Rights and Family Values Bill represent a departure from commitments made to Ghanaians by the NDC during the 2024 election campaign. He maintained that existing Ghanaian laws already criminalize same-sex sexual relations and same-sex marriage, adding that the primary objective of the anti-LGBTQ+ bill was to address the promotion, advocacy and sponsorship of LGBTQ-related activities. The Asen South NP cited several amendments, including changes to provisions defining prohibited conduct and the introduction of new clauses, which he argues create exemptions for certain persons and institutions.
Promotion of and advocacy for activities prohibited under this act. This is the main thrust of the object of the bill. This is what we don't have in any part of our existing laws, for which this bill came about. Clause 2 says that nobody should promote any such things. Don't do things that will entice, advocate for, and make it enticing, incentivize, advertise, campaign for it. Don't do it. But they say that no, insert this immunity. This is an immunity clause. You are lifting them above the law and saying that if you are within these categories, you can do anything that promotes LGBT, that advocates for LGBT, supports and sponsors LGBT, enables LGBT, and just by virtue that you fall within these categories, as for you, you are above the law, you should be exempted.
Meanwhile, government and sponsors of the amendment bill are yet to formally respond to the minority's latest concerns. The Human Sexual Rights and Family Values Bill remains one of the most contentious pieces of proposed legislation in the country.
We said in the House of Parliament because what was expected to be a productive special sitting of the House on Monday ended in disappointment after the House was unable to proceed with key businesses due to the absence of several members of the House and the failure of the Minister for Health to appear and answer scheduled questions. Evelyn Tingma reports.
Parliament traditionally does not sit on Mondays as part of its regular schedule. However, the House last week resolved to sit on Monday, June 1, to address pressing national matters, including an appearance by the Minister for Health to answer questions from members of Parliament. When proceedings began shortly after 10 a.m., the sitting was briefly suspended to allow some issues to be resolved. When MPs resumed after about 30 minutes,